Good evening and welcome to this session of the live virtual classes conducted by the Board of Studies of the Institute of Chartered Accountants of India. Today, we are going to take up a new topic, which is totally in a different path. That is general. That is this now we've completed our researches into the Companies Act. And the portion for Companies Act got over, companies incorporated outside India, over. Now we are moving to other laws which are connected, which are useful laws, the other laws, see, corporate and other laws. These are part of the other laws, one of which is the General Clauses Act 1897. It's a pretty old law. In fact, pre-independence. Just to give you a background, the laws, many of the laws that we use in India now are not post-independence. They are pretty much there for a long time, like including the Indian Contract Act, the Sale of Goods Act, the Partnership Act 1932, and the Indian Penal Code itself, the Civil Procedure Code 1908, Indian Penal Code. Indian Penal Code and the Contract Act were drafted by a man called Lord Macaulay. So, and they were passed by the British Parliament for us, which is possibly why you have the prefix of Indian. Say Indian Contract Act. Why it is not Contract Act? It's Indian Contract Act. Because it was enacted in the British Parliament for the dominion of India, right? The larger India, the larger subcontinent. The point here is, which is possibly why in some of the examples in the Negotiable Instruments Act, you will find people referring to Lahore, Karachi, and all that. And so the logic being, these are all part of one big, Indian dominion, whatever it is. So we have the General Clauses Act, which is again a pre-independence. What was the purpose of this law? And the beauty is, many of these laws, the Parliament of India thought fit to adopt rather than reenact. So we have not bothered, or we have rightly so. Why reinvent the wheel when something is already good and we have it already? Therefore, they have just adopted it with changes implied. Now, you'll find that if you go through the General Clauses Act in its entirety in the book material, the study material will be very boring because it's got a lot of stuff that is not relevant. But still, you go through it once. And my full lecture, if you listen, my long lecture, you will find it is covered. Yeah, every aspect is covered. But in this short lecture, what I will be doing is covering the important and possibly relevant portions of the General Clauses. What is the purpose of the General Clauses? See, there are many words and phrases that need elaborate explanation or clarity. Every law which is passed in Parliament cannot provide for these things. Therefore, they want to consolidate all these meanings, all these expressions in a single law and refer to it. For example, frequently we are asking this question. You are asking, sir, is it financial year or calendar year? Like that. So when I keep on repeating to you, whenever the word year, Y-E-A-R, not E-A-R, year, can't year, Y-E-A-R, Y-E-A-R is used, then it will be calendar year. If they want financial year, they will say financial year. If they want assessment year, they will say assessment year, previous year, whatever. If they say sir, year, then it is calendar year. Now, you will ask me, and you should ask me, sir, who told you? Brahmaji? No, it is contained in the General Clauses Act. We will see that in today's lecture. It is contained in the General Clauses Act. Therefore, wherever in any law, please note it, any law, if the word YEAR, year is used, it always means calendar year. So the idea is to shorten the language because every time We need not say year means a calendar year beginning on the 1st of January and ending on the 31st of December. No. Take it. The calendar here is called the Gregorian calendar. See, India, we use the Saka era also, which begins with the birth of a great king called Salivahana. And Saka era is used. Salivahana was a brilliant king. So he's used. But we, along with the Saka era, we also use the Gregorian calendar, which is, of course, beginning with the first birth of Christ before circa common era and after the common era, which is birth of Christ is taken as the. Now the point here is, so here, just for information, okay, to provide as far as possible for uniformity of expression in central acts by giving definition of a series of terms in common use, right? So one more reason why we use the British system is in India itself, for information, suppose you want to use any of the Indian systems, you'll be in trouble because most of our chronology is based on, see, some of us, for example, in the south and east, the south use what is known as a Sauramana, that is based on the sun entering the year. For us, the sun, when the sun enters the Mesha, the Aries, year begins. Everybody, it is then Shankara and the whatever. But Ugadi, if you see, it is based on Chandramana. That is, it is based on the Amavasya. So that in the same month of Aries, when does Amavasya come? That will be the beginning of the year because they count it from moon to moon. So Amavasya to Purnami, right? And then again Amavasya is 1 month, which could be totally different from your Gregorian calendar. Right. And also the calendar we use in West Bengal will be totally different from the calendar we use in Gujarat or the calendar we use in Tamil Nadu or anywhere else. So that is one of the reasons why we are unable to use the common calendar. Therefore, of course, once upon a time, we were all using Chandramana and we were all following that, but it is not there. And the years have a name. And those, just for information, you see, because many of you should know the heritage. You see, every year we have 60 years, each of which has a name. The year in which we are now is called the Krodhi, year Krodhi, where the name of the year is called Krodhi. And last year, the earlier year was called Subhakrito. And in April, when Makar Sankranti, we changed. The new year began, which is, we call it all over India, we celebrate on different dates. As I told you, because based on Chandramanam or Sauramanam. But the point here is, see, obviously for legal purposes, for counting the due date for a negotiable instrument or for filing of a return, it is very difficult for us to relearn and unlearn. The British occupancy and the 200 years of slavery has made us very much adopted to the English calendar. Therefore, we prefer to use the English calendar for all official purposes. But for all our, festivals or our own functions and celebrations, even birthdays are based on the Chandramana, Sauramana calendars. Right? So this is one thing. Also to state explicitly certain convenient rules. So wherever this word is used, this is what it means, interpreting, so on and so forth. We'll see such cases. What is the meaning of immovable property? Wherever the word immovable property is used, this is what it means, like that. One more thing you should understand is the provisions of the General Classes Act are universally applicable across enactments without exception. So wherever in whichever enactment you find this, you can argue. You might remember when we were discussing the quorum, I made a mention of the General Classes Act. I gave a convenient rule. What was that? Words indicating the plural include the singular and vice versa, or other words indicating the singular include the plural and vice versa. Means plural includes singular, singular includes plural. All that you will find in the General Classes Act. So you can boldly use it, okay, and say, this is how it is. Also to guard against slips and oversights by importing into every act certain common form clauses, so that even if it is not mentioned in a particular act, so long as it is there in the General Classes Act, you can adopt it. Which is why when we are looking for the meaning of a word or interpretation of a word used in a statute, later on when we come to interpretation, we will talk about that. But so we will look ideally within the enactment itself. You see? So the idea, I'll come to that point. to place in one single statute different provisions as regards interpretations of words and legal principles, which would otherwise have to be specified separately in many different acts and regulations. So it's a consolidating act. It is an enabling act, a consolidating act. It's available. It's a nice law. You should love the General Classes Act. And one more thing I would like to add here, and I think it's very important, is we should appreciate the Board of Studies and the people for including this law in your syllabus in intermediate. Because after this, nowhere else you will study it. While later on, some of you may want to become experts in income tax, expert in GST, specialization, etc. So when you go into those complex legal provisions, definitely you will have to use the General Classes Act. So at that time, if somebody were to tell you General Classes Act, you will say, "Kya? General Classes Act? Kya hai?" No, you will not, because you have been taught in the intermediate level itself about, at least you know now that there is a General Classes Act. So next time when you are having a doubt, you will say, let me see if the General Classes Act has something to say about it. Which is what I said. When I want to find out the meaning of an enactment, ideally, I will use the enactment itself. Ideally, I will look for a definition which is given in the section by way of an explanation or in the act itself. Usually, not always, in section 2. In section 2, section 2 of the enactment would I normally have definitions. Just like your Companies Act, section 2 has almost 87 definitions. I don't know the exact number. Around 87. First definition, not 100, less than 100 definitions of words. So these words, you cannot use any other law. You have to only apply Companies Act definition. Certain times in the explanation, you will find a word is clearly defined for that section. You can't use. But suppose neither there is a definition in the section 2 or wherever, no definition. Section doesn't have any definitional clarity. Law itself does not have any definitional clarity for that word. No problem. You can go to, not immediately General Classes Act. You can go to similar enactments. Okay? Enactments which have a similar subject. For example, the word securities, invariably you will find the definition given in the Securities Contracts Regulation Act is used even in the Companies Act, even in SEBI. So you can use similarly in SEBI when later on you come to final and you are reading as part of your self-paced studies on your own, you are studying Securities and Exchange Board of India Act, SEBI Act. If you come across a word which is not defined in SEBI Act, you can go to SCRA, Securities Regulation Act, or the Companies Act itself. If the definition is there, you can use it. Some enactments clearly say a word which is not defined here, if defined there, will have that meaning like that. So you should use that definition wherever. Okay, the word is not defined here, the word is not defined in similar enactment. Then you come to General Classes Act. Check if anything is there. Nothing is there. Then and only then, my dear friends, should you go to the dictionary, which is allowed. Dictionary meaning is, dictionaries are there. For example, you have the Black's Dictionary, Legal Dictionary. Or even you can use the standard dictionaries like the Oxford English Dictionary or the Cambridge or the Merriam-Webster. So many are there. You can use. For example, in my library, I have about, as of last count, I have about 22,000 odd books, nearly 23,000 books I have in my library in Chennai, out of which about 100 are dictionaries. Some are specialized dictionaries, some are general dictionaries. So when a word is given, I can use the definition given in each of these dictionaries. Of course, today, none of all these 100 dictionaries are just beautifully decorating my library walls. But the real dictionary today is in my mobile phone, dictionary.com, which will give me definition from 4 or 5 different dictionaries. In one shot, I will get it for that word. Thereby, but still, when I'm in doubt, I refer to some of the older dictionaries which are there. And I sometimes get some additional weightage by using it. See, all this will be very relevant to you if you're going to become a tax practitioner or a only tax practitioner. If you're going to be in a large corporate or a large multinational firm as a partner, whatever you want to be, you have to remember this law. General Classes Act, and that some of these techniques I'm suggesting to you because you can get your support anywhere. And because when you're arguing a point, You have to be very careful. You have to build your argument. You have to say, this is what the word means. Normally, this is the meaning in which this word is understood. Therefore, the same meaning should be given to that word and not a restrictive meaning. For example, I had one case where the Income Tax Act speaks about gift, whereas there is one more word called settlement. The Income Tax Act does not use the word settlement while exempting. It uses the word gift. So is the gift a settlement, a gift? I have to do research nearly, my submission had nearly 15 pages. What is a settlement? What is a gift? Why? So many authorities have said gift is a settlement is a gift. Settlement is a kind of gift, though it is like that. So the point I'm trying to make is we have to argue. I have to argue because I have to win my case. So the asking officer says no, sir. It's a use specifically. It uses the word gift, whereas you have made a settlement. I argued on that matter and I finished the matter. Later on, I realized, okay, no, whenever I do a settlement, I ensure that by way of gift. So the word gift will be used for natural love and affection without consideration by way of gift. So that there will be no problem about this. I know this may be a little high. I mean, I don't know, maybe a little on 100% what I'm now mentioning is not irrelevant. It may be a little high, but you have to. See, once you come to final, the expectation from you is going to be totally different, right? And see, that's why sometimes I also try to be a little tough because if you want asan here, then that asan won't be there in final. However much asan we try, it will be still tough. So you don't expect asan here. Let it be tough here itself, so that when you go there, it will be easy for you. So this is how we are. So everything, sir, give it to me in easy terms, sir. Explain in simple words, sir. Explain in way I can understand. In intermediate level, we can do all that. Maybe. But final, which is a different kettle of fish. That time you have to prepare. Therefore, now itself raise the bar. You come to one level where if you struggle now and come to that level now, final will be easy for you. This is my humble submission. Okay. So Article 367 of the Constitution of India is mentioned here, and they say, unless the context otherwise required, the General Clause Act subject to any amendment, shall be made therein under Article 33 to apply for the interpretation of this Constitution as it applies. So, General Clauses Act can be used for interpreting the Constitution itself as it applies for the interpretation of the act of the legislature of the Dominion of India. Do you see that word? It is still not taken out. The word. I think it's not fair. I think it needs to be taken out, right? This is a dominion. We were once upon a time a dominion. Just like Australia was a dominion, New Zealand was a dominion. I think Jamaica was a dominion. And in the West Indies, some were Spanish and some were British. For Antigua was British, I think, British dominion. Point is, they were all British dominions. And then, of course, they got independence on different dates. Okay. The Act does not contain any indication as to territorial extent. It is deemed to apply wherever any central law is applicable. Earlier, the laws were not applicable to the state of Jammu and Kashmir. Now, they are applicable to Jammu and Kashmir also. So, the General Clauses Act applies to all areas. Wherever a central law is applicable, the General Clauses Act will be used. So, Section 3 is the definitions in the General Clauses Act. Normally 2, here 3. That is why I said normally 2. Because almost I say Section 2 will have the definition. Immediately you will have a doubt. Sir, you said 2, sir. Now here it's saying 3, sir. Could be. It depends on the whole thing. Now, the word act, I've been using the word act many times, I think, and I have mentioned what is an act. Whenever we say act, it is an act of, act has many meanings in English. Act means to do something. I have acted means I have done something. Again, act means to put on some costume and pretend to be somebody else. That's called act, natak. So now many meanings are there. But here in this, that is the problem. In English, single word will have many meanings. Contextually, you have to understand. And if you misapply, the meaning itself will change and understanding itself will change. So you have to be very careful about using English words in context. So when the word ACT Act is used with the capital A, it means an act of parliament. Okay. Whereas here, they are saying act, used with reference to an offense or civil wrong, shall include a series of acts and words which refer to acts done, extend also to illegal omission. So, one important point. Here, the word ACT is the doing of something. What is the act for which you are doing? Okay. So, not repaying the deposit is an act, punishable. Okay. Not honoring a check is an act, punishable. So whenever we say act, we don't only mean something done positively or proactively or consciously, but also any illegal omission. Not filing a particular return on due date, not remitting the tax to the government of India. These are all illegal omissions and are punishable. And these are acts. So the word ACT, act, used with reference to an offense or civil wrong. Okay, it includes a series of acts and words. Though the word act is singular, series of acts. An act required to be done cannot necessarily mean a positive act. It may also include one which one is precluded from doing from degree. For example, when you are not supposed to do and you do it, that is also an act, punishable. So this definition is based on sections 32 and 33 of the Indian Penal Code. It applies to civil wrongs as well as crimes. Civil wrong means when Mr. A does something that prejudices the rights of B. Civil wrong. I have land adjacent to your land, and one fine morning I take out the fence and take another 3 cents of your land. I change the fencing. You come and see, you find your land is no smaller, my land is bigger. There is a civil wrong. What is the remedy? File a suit against me. Sorry, don't bring gundas and hit me, push the fence back. You cannot, sorry. I have done, see, this is the problem with law. Since I have already pushed the fence that side, I am now in the better side of the law. Surprisingly. You know why? Because you will say the land belongs to you. I will say it doesn't belong. Now you will have documents. I may not have documents. But who has to file the case now? You. So you will go file the case, produce all that. My lawyer will simply come and stand up and say, I want time. That's all. Then I will produce some stupid documents which are nothing on this. Case will drag on. How many years? 7 years. That's it. 7 years later, you know what will happen? You will be so bored and you will have spent so much money for lawyers that you will finally come to me and say, let us go for a settlement. See, I'm not trying to comment about the law. I'm saying that is how the law is. Which is why many times I just suggest to my people, do not go to court. Prefer to go for settlement then and there. Go for mediation, solve your problems. Go for arbitration, solve your problem. But better still, don't have any lawyers at all, don't have any judges. You do it on your own with your auditor or somebody who is known to both of you and finish it. That is better than going to court. Okay, this is the general suggestion. So that is a civil wrong. When one person prejudices the rights of another or prevents another from enjoying his rights, that's called civil wrong. Act includes illegal omissions, but does not include a omission which is not, that is, knowingly when I do something, it is not an act. Okay. I did not know that the law was there. Okay. Such a law is there. Central act shall mean an act of parliament. Okay, and shall include an act of the Dominion legislature or of the Indian legislature passed before the commencement of Constitution. As you are well aware, the date of commencement of the Constitution is 26th January. 26th January is my birthday, but that is 1966, whereas the Constitution was commenced on 1950, 26th January 1950. Therefore, we celebrate this as the Republic Day. Okay. An act made before such commencement by the Governor General in Council of the Governor General acting as legislative capacity. You will notice why this law is so old. It predates the Indian Parliament. The legislating body of the Sovereign Democratic Republic of India. This was before that. Even before that, it predates the Constitution of India. But now some more definitions we are going to see. I have been selective. If you want, please go through the Board of Studies material, which is beautifully arranged. Also, if you have the time for it, download the, or rather, go to the link and listen to my or watch my long lecture for this topic, all the topics. See, the idea is that you would have seen it. And now I'll be quickly running through it. And if you have any doubts, you can ask me. That is the idea of this sessions. Affidavit. Now, this is a nice word. Have you heard of this word affidavit? I'm sure you have. The word. Sometimes we use the word affidavit. Affidavit is an affirmation, a solemn statement, a declaration. Affirmation means confirmation or statement of saying that this is what happened. Okay. Many times there is no witness, there is no proof. You can say, I aver that, I give a solemn statement that, okay, this is what happened. That's called an affidavit. Okay. I'll give a simple example. In those days when physical share certificates were there, even now for some of the unlisted companies, private companies, etc., there would be physical share certificates. So you are a shareholder of a company and you have lost the physical share certificate. Now you want a fresh share certificate from the company. So you have to write a letter to the company secretary, and he will say, okay, how do I know? You give me proof. So you send some proof and all, but no. The original certificates are not there. How did you lose it? There was a flood, and in Kerala, complete flood. Everything got gone, everything, including these papers. No. How do I believe? In a Kerala flood, everybody knows here. Check up on my district is here, my house address, this is where the flood happened. No, that is okay, but I need an affidavit. So you have to take out an affidavit, take a 20 rupees stamp paper, which is, I don't know, Kerala, in Tamil Nadu, it is 20 rupees, I'm sure. All over India, it's 20 rupees. Take out and write out an affidavit. So you'll say, I so-and-so, son of so-and-so, age at so-and-so, residing at so-and-so address, hereby solemnly affirm and state as follows, or solemnly affirm and declare as follows. Okay. If you are a Christian, you cannot swear. But if you are not a Christian, I can swear. So I can say solemnly affirm, declare, and swear as follows. And then you will say as follows. Then say, 1, I am so-and-so residing at this. That I am the shareholder of this company, holding shares, having registered folio number so-and-so, and listing to number so-and-so. These shares were kept by me in my house, in the locker or whatever you can say. And during the flood in Kerala on such a day, it has been, my entire property was washed out and it became lost. Okay. This is called a statement of fact. So, affidavit shall include affirmation and declaration. Okay. Now, sometimes, see, normally, affidavit is a sworn statement where I swear that whatever, then at the end of the affidavit, there will be something called an verification. You can check it out. Even in the Income Tax Act, if you check out the income tax return, in case when you're doing your articles, you're asked to file the income tax return online, check out the return. Finally, there will be something called a verification. There you will find an affidavit is there, wherein you will say, I solemnly declare that what I have stated above is true to my knowledge and belief, to the extent of my knowledge and belief. Okay. So that is nothing but making the entire affidavit. It's just you are only. So tomorrow, if you are found to have made a wrong statement or a false statement after verification, then it is an offense. That is a separate offense, punishable separately. So when your income is so much, you have declared so much less, then you are saying it is true. Therefore, that's a bigger thing. Okay. Because it's a penal offense. Anyway, a lot of penalty prosecution also. In some rare cases, very, very rare cases, they might take it up. Anyway, so there are two important points derived from the above definition: an affirmation and a declaration. In case of persons allowed affirming or declaring instead of swearing. See, swearing is because some religions, you are not allowed to swear. No. most Christians cannot take the name of God in vain. Therefore, you are not allowed to swear. In instance, you can simply affirm and declare rather than swear. Okay. So there is so you need not take an oath, okay, for use. Oath shall include affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. Right? To take an oath. Swear means with its grammatical variations and cognate expression shall include affirming and declaring in the case of persons by law allowed to affirm or declare instead of swearing. So you can, if you think you cannot swear, then affirming and declaring. You can just affirm and declare, okay, on solemn. So the word affidavit, oath, and swear are same meaning. So whether you say on oath or swear, when you go to court, you take an oath on the Bible or whichever holy book you believe in. You have to say, I declare that what I'm saying is the truth, the whole truth, nothing but the truth. These are all basic concepts. The idea is to put them in one place so that later on, again and again, we need not ask. I'll tell you one more thing. You might ask me, sir, how relevant is all this to me? I don't know. If you're going to be pure finance guy, running a company, even then I'll tell you, there will be so many occasions when you will have to prepare an affidavit. Or you might have to take an affidavit and show it to your MD and make him understand why he is signing it. Because so you have to tell him, sir, we are giving this affidavit because they like this. GST wala is saying, I'll have to give you this benefit, means you have to give me. So we are doing this. But explain to you. Because sometimes they will say the MD has to sign. Though even you as a CFO can sign, some things like affidavit you cannot sign. Only the managing director can sign on seal under this foreign on behalf of the company. So you will have to explain to him. He won't sign just like that. Whatever you put before him, he won't sign. You cannot explain to him. For that purpose, at least you should know. Of course, if you aspire to become a tax expert or a GST expert in GST specialization, authority on GST, authority in income tax, whatever you want to become, you have to study Income Tax Act in and out first. In addition to that, you should be thorough with General Classes Act, interpretation, all that. Okay, you by the time you finish here, that is why many tax specialists will end up doing a law degree. Because they would need it whether they like it or not, because they'll be appearing before tribunal. And once they go before tribunal, it will be like almost court. So they will need to know, though there is no procedure, it's a quasi-judicial body, still minimum court procedure will be there, minimum, argument, minimum way of approaching, etc. will be there. So be careful. Anyway, financial year shall mean the year commencing on the first day of April. So, thus, as per General Classes Act, year means calendar year, which starts from January to December. Financial year starts from first day of April. Calendar year starts from first day of January. So, the calendar year is the Gregorian calendar year, whereas the financial year is the first day of beginning on the first day of April. In fact, there is a proposal by our enlightened Prime Minister that this year, the so-called financial year, will also be sort of made 1st January to 31st December. So it's not yet happened, but there is a proposal to change it. There was a proposal to change it from 1st April to 1st January and make it uniform. So that year and calendar year and financial year will be the same. That's a beautiful concept, and we eagerly wait for that, because that will create so much confusion, so much clarity, lack of clarity, that it will be fun for at least 1.5 years. It will be fun and jokes and games, and everybody coming out with articles in Tax Guru, in various places as to what they think, adding to the confusion and the ignorance. And finally, we will all know why are we doing all this? Because most not even developed, most superpowers have their they have their financial year from 1st January to 31st December, except of course America, where the financial year begins on 1st of July. So we'll also move to 1st of July is what I feel, when we would be aligning with the superest power of all in this world. And we will also be a superpower. They're changing the financial year? Yes. I hope. I don't know. And not really, but or we will prefer to go. We will use the same thing. So we'll get used to January to December. Anyway, see, remember during the British period, it was January to December. It's only after independence that we decided to make our year as 1/4. The assessment year previous year became 1/4. Income tax act bought that first. Then Companies Act followed suit with the uniformly. Before the Companies Act 2013, then I think the uniform previous year came even earlier, even the older act amendment. So before that, for company law purpose, we can have any year as a financial year. Company law, you can have any year. Whereas for income tax, they said only 1/4 to 31. Income tax was always 1/4 to 1st day of April to 31st of March. That there was no doubt. So we used to have, that was a beautiful tamasha where we will be closing the books once for Companies Act purpose, auditing, statutory audit and all that. And again, we will strike the balance sheet for 31st March, which may not be my year, only for the purpose of tax audit. So almost every 6 months, there will be an audit. And not only tamasha, but also a lot of fees for auditors because we'll do 4 audits in a year. Well, we earlier did only 2, rather 1. Now we'll do two audits per year. And almost in the 1 year, we'll be engaged in continuously an audit. If you have this. Therefore, they said, no, let us have uniform. So they came to 1/4 to 31(3), where the Companies Act also, which is where we are now. Things are smooth going now. So any amendment of 1/4 should be uniform. It should not be only in Companies Act. It should be in Income Tax Act also. That is first, then Companies Act. Then, let us see when that happens. Month shall mean a month reckoned according to the British calendar. The British calendar is nothing but the Gregorian calendar, right? The British calendar is nothing but the Gregorian calendar. Year shall mean a year reckoned according to the British calendar, beginning on the 1st of January and ending on the 31st of December. So this is more for your information. So please don't have that worry, concern. Whenever you're reading a law or anything, just see what is it. Is it saying year without any prefix? Then calendar year. Some prefix is there, then go for the definition given. Assessment year defined in Income Tax Act. Previous year defined in Income Tax Act. Financial year defined in Companies Act. We already saw that. Okay. Good faith is a word. You'll find it being used in many contexts. The Negotiable Instruments Act, which is luckily out of your syllabus. Luckily, not luckily for the Act. Luckily for you, it is out of the syllabus. For the Act, there is no feelings or emotions. For you and me, it is there. For I have to teach and you have to learn. So it's not there. So we are both happy and lucky. So Negotiable Instruments Act uses the word good faith. When we talk about holder in due course, we say somebody who has obtained an instrument for consideration in good faith. Similarly, sale of goods act, sale by non-owner. Anybody who has obtained goods, where goods are obtained by means of by fraud or thing, where the consent was induced by the free consent is not there, then the contract becomes voidable contract. So such a voidable contract, till it is avoided, it is valid. A and B, A has induced B to enter into a contract by practicing fraud. A has induced B to enter into the contract. Now A obtains the goods and sells it to C. Now, till such time B resigns the contract, it is only voidable, it is not void. The minute B resigns it, then it becomes void. So the very important question is, when did the transfer happen? 1. 2, the man who got it should get it without knowledge, in good faith, without knowledge of the defect in the title of B. Of A. So when C buys it from A, he should not know that it was obtained by fraud. And before the contract is resigned by B. A induced B to enter into. So good faith is used. What is good faith? Okay. Also, see, I do something to you or for you with the intention that I want to benefit you, but the effect is that you are suffering. Okay. Many times, people do things with good intentions, but the result is not what they expected, not what the other person wanted at all. Right? Am I correct? With good intention, parents have been telling children study, 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 study. In that process, the child loses its communication skill, loses its interpersonal skills, nothing. Study, study, study. So I saw one. Recently, I went to view an apartment which I'm thinking of buying. The owner of that apartment is a daughter studying. She says, Uncle, I study till 2 a.m. in the morning. For what? 10th standard. I said, why? What? No, I want to be the topper in my class. Everybody wants to become topper. Who will be the topper? Me. So in good intention. See, the intentions of the parent are honorable and honest. But what happens affect 22, 23, the child, once the child gets into college and they realize, my God, I have not enjoyed my life. Then they totally go off and they don't study well. They said, enjoy life. Something happens. So the parent is worried. Why did this happen? What happened? Or better still, the child goes to college, studies extraordinarily well. Maybe all time, they get all India rank in CA and then get a job and then go abroad and then forget the parents. And to sit in Los Angeles, not bothering about whether parent is alive or dead. The parent here will come and write to me, Mr. Srikanth, my son is not king, not talking to me. I said, look here, you only told him to study hard, become successful. He has done that. No, you didn't take care of me. That was never in your agenda. So many times people do with good intentions, but the effect is not what they wanted. So good faith is something which is done honestly, whether it is done negligently. So the intentions are honest, but it has resulted in negligence also. Anything done with due care and attention, which is not mala fide, when the intention is not dishonest. Mala fide is opposite of bona fide. Mala fide means good intention, bad intention. Whereas good bona fide is good intention or good, shall we say, confidence or good. So anything done with due care which is not mala fide is presumed to have been done in good faith. So the word good faith has been defined differently in different enactments. If it is defined, you have to go by that. This definition does not apply to the enactment which contains a special definition of the term good faith. Then you have to give that. But if there is nothing given there or nothing repugnant in subject or context, you can use this definition of good faith. Okay. So the definition of good faith is generally understood in the civil law and which may be taken as a practical guide in understanding the expression in the Contract Act. Nothing is said to be done in good faith which is done without due care and attention as is expected with a man of ordinary prudence. This is very, very strange. What is good faith? Any act, see, good. Nothing is said to be done in good faith which is done without due care and attention, as is expected with a man of ordinary prudence. See, man of ordinary prudence. See, I'm not trying to introduce unnecessary stories in this, but about 15, 20 days ago, in the morning around 9 a.m., I got a call from a friend, from a distant relative, you can say. He called me and he said, Srikanth, is this your number? And he gave some number, mobile number. My number. Hey, this one, my number. No, is this your number? Confirm. It's not my number, man. I kept the phone. Then again he called, about 15 minutes later. And he said, please confirm, this is your number or not? It is not my number, Baba. What is the issue? Then he says, your Facebook account has been hacked. So my Facebook account is very much safe. What has happened is they have created a similar account like mine, and they have sent a message from that account through some mobile number to this gentleman, and they have asked him for 20,000 rupees. So your friend, without due care and attention, as is expected with a man of ordinary prudence. Are you able to understand now what he should have done? A man of ordinary prudence. He knows my regular number. He knows I am a practicing chartered accountant in the city of Chennai, and forget it. That I will borrow 20,000 or not. 20,000 is a big amount. You should at least call me and ask me. So Srikanth, I got a message like this. This is your message. Do you want 20,000 rupees? Without all that, our friend has sent money Are you now able to understand? Is that good faith? No, sir. Without due care and attention, as is expected of them. Then he was calling me, he said, I believe that it is you. I said, you believe it is me is not enough. Did you ask me if it is me? This is what a man of ordinary prudence will do. Okay, I'm giving this example to help you understand what is due care and attention. As is expected of the man of prudence means being careful. Prudence means being careful. Prudence, being cautious. All chartered accountants are meant to be prudent. We should be serious. See, whenever we do something, we should not be over optimistic. We should look at all the possibilities of when it will not work. Of course, we should be positive attitude and hope for the best, but prepare for the worst. That is what a man of ordinary prudence will. We will prepare for the worst, but hope for the best. Always we hope for the best. We hope for the best, and we pray to God that He should help us with all the humble but holy confidence that He will help us. There, no negative. But when planning and preparing, we should look at all the negatives and see where it will go wrong, what will go wrong. That is what a man of ordinary prudence so if I say man, remember, man includes woman also. Okay, that also will come in this law only. So an honest purchase made carelessly, without making proper inquiries, cannot be said to have been made in good faith, so as to convey good title. Okay, so an honest purchase made carelessly without proper inquiries. Okay. So we have to, whenever you buy, you have to inquire as to what the product is, especially when you're buying online. Yeah, so now online trading, online sellers are careful. Whenever you have a complaint, they immediately replace. Why? Because they want you to have confidence in the entire framework of electronic market, e-commerce, and internet-based buying and all that. Later on, I'm sure there will be unscrupulous people trying to cheat. Already there are many sites where they defraud the customer by giving all sorts of false details and false promises. So here's the question from the examination. What do you understand by the term good faith? Explain it as per the provisions of the General Laws Act. Mr. X purchased a watch from Mr. Y carelessly, without proper inquiry, whether the purchase made could be said to be made in good faith. So I think I've highlighted it now, that without care and without proper inquiry, whether the purchase made could be said to be made in good faith. In the given situation, Mr. X purchased a watch from Mr. Y carelessly without proper inquiry. Such a purchase made could not be said to be in good faith, as it was done without due care and attention, as is expected of the man of ordinary prudence. An honest purchase made carelessly without making proper inquiries cannot to have been made in good faith so as to convey good title. Okay. Mrs. K went to a jewelry shop to purchase diamond ornaments. See, the owners of the jewelry shop are notorious and indulging in smuggling activity. These fellows are so notorious that the whole world knows that these are smuggling fellows. Our lady, Mrs. K goes there and she purchased diamond ornaments honestly without making proper inquiries. Was the purchase made in good faith? In the instant case, the purchase of diamond ornaments by Mrs. K will not convey good title. See, point here, my humble view is, question is whether Mrs. K can return the jewelry. No, because she should have made all the necessary inquiries. She has not done it. That is the point. See, suppose it's a valid sale, she can go and demand from them. In the meantime, these are smugglers. Yeah, they have gone. So now she can go to the police and say, I want it back. The police will say, Madam, you should have been careful. Why you have not done it? You can now claim. Immovable property shall include. The lesson I'm getting out of this is always be careful, be prudent. Don't, especially in financial transactions. Okay. Of course, you should be prudent in life also. Okay. Even in emotional cost, you see, when you have a relationship with a person, there's an emotional cost. Just like a financial transaction has a financial cost. You have to invest emotions in a relationship. So before you are willing or ready to make that emotional investment, definitely you should take that due care, which an ordinary person of ordinary prudence would do. Okay. Similarly, for financial transactions also. Right? Now, coming to the point of immovable property. Now, the word immovable property, generally accepted. There are many enactments which define the word immovable property. There are enactments like the Sale of Goods Act which define movable property. Here they have defined immovable property. So if at all any act is there which does not define immovable property but uses the concept, then you can use this definition, 3 subsection 26. Immovable property shall include land, benefits to arise out of land, things attached to the earth, or permanently fastened to anything attached to the earth. Which is why in Sale of Goods Act, they will say specific exemption will be growing crops. For mobile goods, specific exemption will be mobile. One of the specific exemption is growing crops. So land, benefits to arise out of land, and things attached to the earth, or permanently fastened to anything attached to the earth. See, a machinery, is it movable or immovable? I'll ask you, sir, is it permanently fastened to anything which is attached to? For example, there will be a bolt, there will be a metal plate, and that metal plate will be bolted to the ground. And this machine will be permanently fastened through another nut, fastened permanently to that metal plate, which is attached to the earth. So such a machinery would be strictly called immovable property. It's a very important definition. Permanently, when you are later on, when you are dealing with whether it is a machinery, whether it is immovable property or movable property, you have to understand, sir, is permanently fastened, anything attached to the earth, then it is immovable property. So where in any enactment, the definition of immovable property is in the negative, not exhaustive. So because there are other enactments where immovable property is not defined, movable property will be defined. Then you can use the general clauses. X owned land with tamarind trees. He sold his land and the timber obtained after cutting the 50 trees. Okay. X wants to know whether the sale of timber, see, land is immovable property. However, timber, because once the timber is cut, then it is not attached to the earth or permanently fastened. Therefore, it becomes movable property. Here, movable property is not exhaustively defined. They say movable property shall mean property of every description except immovable property. So if you bring it under immovable property, then it becomes, if you are unable to bring it under immovable property, it becomes, that is why let's share electricity or movable property. Any actionable debt, we call it. See, when A owes money to B, that debt now can be sold. In which case it is a movable property. Share, it's a movable property. Remember, it is not the piece of paper that you sell. It is a conceptual. You are selling a share in that company, right? So that is not immovable property. Therefore, it is movable property. So if you ask me, sir, where is the share? See, this watch is movable property. No doubt about it. Because you can touch, feel, intangible. Can you touch a share? You cannot. But still it is movable property. Electricity. Can you touch it? No, should not. But it is still movable. Why? Because it is not immovable. So when the electricity board supplies electricity to you, they are supplying immovable property. So, but can you ask, where are they storing the electricity? Is it stock in trade? Electricity cannot be sold. It has to be passed. It has to be continuously kept in movement. Okay, you understood. Except in batteries and in substations, we cannot store electricity. It is moving. Electricity is an elemental force. Okay, that way. That way, if you look at it, electricity is an elemental force and a sub-element of fire. Basically, the main element is fire. Electricity is one type of fire. For me, there's one more vidyut, we say. There is a energy, electricity. Okay, so mobile and immovable property. Okay, so you might have a doubt here. If you have a doubt and if you don't ask also, I'll ask. Sir, you are telling benefits to arise out of land. It's not the timber, a benefit arising out of land. Agreed. Now, let me put it this way. I am having a land. You are with me. You are all the big people. I am ordinary auditor. You are all big shots. So you are having a land, 50 acres. You have attached it. You have planted teak trees, teak plant, teak. So you are selling the land to me together with the teak plants. So why me? I can't buy from you. You are selling it to another very rich man who can buy it from you. That you are selling the land along with the teak trees. Now those teak trees, are they immovable property or movable property? Immovable. Kyun? Because they are attached to the earth. Also, they are benefit to arise out of the land. So when the tree becomes a large teak tree, that is, but once it is cut, it is no longer attached. Thereafter, it becomes movable. It is not immovable. The minute you say it is not immovable, it is movable. It is all. You might think you are unnecessarily confusing me, sir. Okay, you are wantedly doing this like that. I agree. Maybe I am. I don't know. But you have to become conversant in this mental gymnastics. If at all, you see, if one of your goal is, sir, I know I want to become a tax expert, sir. And I'm going to become an authority on income tax. Please. But for that, you should be thorough in this mental gymnastics. Because you will have to take the one word and interpret it. Then only you can win the case, or at least give an opinion to the client, or whatever you want to do. That is why you have to learn this. Okay. Many of the things in life, who wants to learn, my dear friends? But still we need to learn. Why? Because unless you learn, you cannot achieve the goals that you say you want to achieve. That is the problem. That is why we have to learn all these laws and all that, unnecessarily learning all these things. Because your goal is to become a tax expert. That is why. I hope it is one of you, few of you will have that goal. Imprisonment shall mean imprisonment of either description as defined in the Indian Penal Code. There are two types of imprisonment. One is called simple, the other is called rigorous. Okay. So, Section 53 of the Indian Penal Code, the punishment to which offenders are liable under that code are imprisonment, which is of two descriptions. Rigorous is with hard labor, as our freedom fighters were made to undergo in Andaman, Palayangottai, where they underwent rigorous imprisonment, where they lost their lives, like a famous freedom fighter from South, V.O. Chidambarana, was also known as the first man to build and run a ship, the first Indian to run a shipping company. All these people were in jail for hard labor under the Indian Penal Code. So, when the Act provides that an offence is punishable with imprisonment, the court may, in its discretion, make the imprisonment rigorous or simple. So, the word imprisonment can mean both rigorous or simple. In any legislation or regulation, it's very, very important provision. This is a very, very important and very, very interesting provision. Kindly concentrate on what I'm saying. In any legislation or regulation, it shall be sufficient for the purpose of excluding the first in a series of days. You want to exclude the first in a series of days or any other time or period of time, to use the word from. So whenever the word from is used, then you have to exclude the first in a series of days. Exclude the first. And for the purpose of including the last, okay, we will use the word to. So from the 1st of April, from the, say, 29th of May to the 3rd of June. From, means you lose, once the minute the word from 29th of May is removed, used, then 29th of May to be removed to the 3rd of June, then 3rd of June is to be removed. Okay. So the 3rd of June is to be included. The date from which is to be excluded, and the date to which is to be included. Which means, suppose I say the period of grace will be from 29th of May to 3rd of June. So, in some clause. So, the period of grace period will begin 29th of May is not to be included. 30, 31, 1, 2, 3. 5 din. 3rd midnight, your period of grace is over. Suppose you are getting Mr. A owes B money. So A goes to B and say, give me time, give me time. Okay. I will give you time, man. To third, you take, yeah. Today's, you're saying not. 12th you take, 29th. Means you told it yesterday. From 29th to 3rd June, man. So the minute the word from is used, you exclude that date. Start counting from the next date. This is applicable. I gave an example of contractual, but this is applicable in any legislation also, only in registration. So in any legislation, if they say from, then that should be to, that should be included. So we have already studied dividend. So you are all experts in that topic. Therefore, you are expected to know. See, this question asked in the examination is a two-pronged question. It is testing you on General Clauses Act and the Companies Act. See how you can say two prongs. So both you should know. That is why this question, if I have to write the book again, I will not know which topic to include it. Should I include it in dividend or should I include it in General Clauses Act? What I will do is I will include it in General Clauses Act. When refer to it, I will give the same thing in dividend also. In both the places it will come because it has relevance in both the places. So COML Limited declares a dividend for its shareholding in its AGM held on 27 September 2021. So declaration is 27, referring to the provisions of the General Clause Act. Date during which COML Limited is required to pay the dividend. So the dividend should be paid within 30 days from 27 September. 30 days from 27 September. So COML Limited declared dividends on 27/9. Under the provisions of Section 127 of the Companies Act, a company is required to pay the dividend within 30 days from. The minute you see the word from, exclude 27th. Start counting from 28. So 28/9 to 27/9, 30 days. So in the series of 30 days, 27/9 will be excluded, and the last day, the 30th day, that is 27/10, will be included. Accordingly, COML Limited will be required to pay dividend within 28/9 and 27/10. Ideally, midnight 27/10, time over. The date during which COML Limited is required to transfer the unpaid dividend or transfer the unpaid or unclaimed dividend to unpaid dividend account. You remember? I dare say you remember. The limit is 7 days from the 30th day. Am I correct? So the transfer of unpaid or unclaimed dividend. As per the provisions of Section 124, where a dividend has been declared by a company but has not been paid or claimed within 30 days, then it should be transferred to the unpaid or unclaimed dividend account within 7 days from. Again, the word from. So in Hindi we say na 28 say 27th, or rather 27th say you have to pay within 30 days. So 27. So you exclude that. Then you will get 28 say 27th. I know little Hindi, not to speak fluently. Thoda. Okay, so within 7 days from the date of expiry of the said period of 30 days, transfer the total amount of dividend which remains unpaid or unclaimed to a special account to be opened, etc., etc. That you know. Point is, for counting 7 days, you should not include 27/10, which means you should begin from 28th October. So 28 onwards, 7 days. 28, 29, 30, 31, 1, 2, 3. So 28th October to 3rd November, both days inclusive. Okay. So this is again a question. See how regularly they have asked this particular topic. So you might want to be familiar. Should you study it again? You know it now. Remember it. Yaad rakh dijiye. That's all. So the SEBI regulations was issued by SEBI wide notification 2015 with the effect from 1st January. Okay. Now as per section 5 RNA, etc. If any specified date of enforcement is prescribed in the official gazette, the act shall come into force from such a date. So thus in the given question, the SEBI shall come into force on 1st January 2016. See, what you should know is how does it, I don't know if I taught this to you earlier, but if I have not or whatever, anyway, for interpretation, you should understand this. See, an act of parliament will be first proposed in parliament, then seconded, right? Then in the Lok Sabha, it will be put to vote, passed. Then it has to go to Rajya Sabha to vote, passed. Obviously, there will be oppositions, they'll be talking, people, blah, blah, then put to vote. Obviously, on what majority shall have its say? And go on. Two houses of parliament. Then, because in India we have a president, the president has to give his assent. Normally, the president will not refuse his assent. Rare cases. He will not refuse his assent. But if it does, then that's a big thing. And so the president will give his assent, chop over. Then nothing happens. It has to be notified. Where? In a book, in a paper called Official Gazette. There are two gazettes. The Official Gazette of India, which is central enactments are published in the OG, Official Gazette of India, whereas state enactments are published in the State Gazette. So each state has its own gazette in the publication. Also, state laws will be passed in the, you see, in many states, there are no two houses. Okay. So you have only the legislative assembly. Okay. So they don't have an upper house, right? And there's no legislative council, only legislative assembly. So it will keep going, and legislative assembly passes, then governor. The governor will have the role of the president in the state. He may or may not give the assent. Some governors do make life miserable for the assembly, legislators, the ruling party, by not giving the assent. Whatever. He has the constitutional power. He might say, send it back and say, no, we pass it again and bring it. It changes. Wow. It's the governor's prerogative. But if it doesn't get the assent of the governor, then, or the president, when it gets then it has to be notified in the Official Gazette or the State Gazette, as the case may be. But the date of notification in the Official Gazette is not the date on which it will come into effect. It will come into effect from the date mentioned in the notification. Please remember, the Companies Act was notified, the 13 Act was notified piecemeal. The Companies Act 2013 was notified piecemeal. Piecemeal means over a period of time, section by section. So it used to be a nightmare. We have to keep track which section has been notified, which is not notified, when it was notified. Not only that, one section will be notified partially. Another portion of that section will be notified later. Nightmare on Elm Street. And finally, they notified the law. Finally, the law was born, completely notified. Then they made changes. The amendments are to be notified again. Rules amendment will be there. That has to be notified. So luckily now for the last about 2.5 years, they've kept quiet. No major amendment, no major fiddling with the law. Last was the small company thing. If you had nothing major, minor are there. Nothing major. Inshallah, let it be so. What is there? Let them make changes, yeah. We will pray that there should be no changes before. Even if there are changes before September, you don't worry. For your exam, what we are now studying only will come. Because we have the 6 months car rule. So any amendment made within 6 months from the date of your exam will not be applicable to you. 6 months. Sometimes even they might extend that also and say even if certain amendments which were made, 6 months rule is there. If we are writing the exam on September, go back 6 months. Any amendment made during that gap of 6 months will not be applicable to you. Only any amendment made before 6 months will become. That Board of Studies, we have an excellent team of faculty. They will continuously do research and see to it that it comes to you in the form of RTP, revisionary test paper, or some method will be announced. Those portions will be given to you. You need not worry about it. Instead of wasting your time worrying your head about it, you study. And remember what is there. See, there are so many sections which are there. Study that instead of worrying about the small amendment, which definitely the Board of Studies will give you the necessary input in the right way at the right time. So the process is like this. So sequence. Passing both the houses of parliament, assent of president or governor as the case may be, then notification, Sometimes, it say come into with immediate effect. That means date of notification. They will say in that notification, they'll say this shall come into effect from the date. Sometimes they will notify it in the official gazette and will say will come into effect from such date as the central government may announce from time to time or may announce. In which case, publication in the official gazette has nothing to do with them. Thereafter, they will come out with another notification, another circular, which will notify the section. For you to understand, the section amendment will be notified in one circular. On that date, nothing happens. They will say, we will tell you when it will affect. Then there will be one more circular. Then they will say, so-and-so amendment is now notified, made applicable, made effective. So it will come into effect only from that date. Okay? So this for your information, which makes life very miserable for professionals who have to that is why you have to constantly update. This is section notified, not. When was it notified? In the Income Tax Act, it's even more funny because Finance Act will be passed in Parliament. It will come into effect from that day. So when was it done? In which assessment year this amendment came? It's applicable to which assessment year? Because some amendments will be applicable to earlier assessment year. Some will be applicable only forward. So which is what, where? Oh, before we undertake. So that's why whenever you are doing any research in income tax, anchor the assessment year and go to the wordings of the statute for relevant to that assessment year. It's possible. Today you can go to the income tax site and you will get the complete history of that section. Every word, when it was amended, when did the amendment come into force. So if it doesn't fall within your assessment year, then you go to the year which yours is applicable. Take it. There are some subtle points like reopening and all, when it can be reopened from certain amendments came. So that makes it exciting. And it also makes it interesting. Except you have to be meticulous and prudent and careful while you do your research for your client or for the patient. Okay. Where by any legislation or regulation, any act of proceeding is directed or allowed to be done or taken in any court or office on a certain day within a prescribed period, when if that court or office is closed on that day or last day, the act or proceeding shall be considered as done or taken if it is done or taken on the next day afterwards on which the court or office is open. See, for example, in most of part of India, summer, so courts are closed. Almost till June 6th, it will be closed. Only then courts will be reopened. So in case your due date for filing the appeal falls in this period, you will not be able to file. So you have to wait till the court opens. On the first day when the court is open, you can go and file. Similarly, during the pandemic, the income tax department was closed for 45 days, almost 60 days. Thereafter, they allowed filing. Strict quarantine, strict social system, whatever it is. During that period when it was closed, you have to file it on the first day when the office is open. First working day. So this is only reinforcing the concept. Kindly, it's available in the long lecture. Do go through it. Measurement of distances. Distance shall be measured on a straight line on a horizontal plane. So you should take point A, point B, draw a straight line, measure that. That is how distances should be measured. This is further reinforced in the Income Tax Act, where if you want to know whether it's agricultural land, 9 kilometers, you have to take it as the crow flies. See, a good crow, which is not a drunk, where a drunken crow would be going zigzag. Okay, whereas the normal crow, if it goes straight. So such a straight flying crow, which is nothing but straight line on a horizontal plane. Okay. So there are two ways to reach city A from city B. By roadway, it is 100 kilometers. By waterway, 80. How is the distance? See, neither roadway nor waterway. Unless a different intention appears, it should be measured in a straight line. For that, what you should do, you should take a survey map and see the scale. And then use the scale to draw a line and measure in centimeters. And then see 1 centimeter is equal to how many kilometers. And then see how many centimeters. Those of you who studied in 10th standard geography, I don't know, I had something called map reading. So we do use a survey map and we will tell what is the distance between the two places. but on a straight line. So, whereby in case any duty is being prescribed, okay, then if it is for a part of the year, then it should be pro rata, proportionately. Okay. Gender and number we've already seen. I don't want to waste your time. Okay. Masculine include all that. Plural ways. Already we are aware of this. But be careful. There should not be any repugnance. Okay. So there should be no repugnance. See, certain words you cannot impute directly. So also when there's a common word, then you should not interpret male and female. No. Okay. So the word bullock is a common term for both cow and ox. So usually means a bullock is a word only for ox. Bullock means male. You cannot say, sir, bullock includes cow. Bullock is a bullock because there are some things a bullock can do which a cow cannot do, or rather, a cow can do which a bullock cannot do. Therefore, if you keep exchanging these words, it may be a difficult. So, in the context, it is there you should not. They wanted both, they should have used cattle. There is a common word for bullock and cow, cattle. They use the word cattle. Instead, they use the word bullock. That means only male cow, male. Where any power is given to the central government, it can be exercised from time to time as occasion requires. Okay. Wherever there's a power to appoint, it automatically includes the power to appoint ex officio. Okay. Ex officio means so and so will become automatically, like the chief commissioner of income tax will automatically become a member of that committee. Automatic. So whoever is the chief commissioner will automatically, principal chief commissioner will automatically become the member or chairman of the committee. So power to appoint to include, suspend, or dismiss. So the minute authority is given the power to appoint, automatically it is unless there is a different legislative instinct, they can remove or suspend. Similarly, power to issue a circular or rule, we can add, amend, vary, resign, etc., etc. A provision should not be punishable. A person should not be punishable under two offenses for the same act. Where an act or omission constitutes an offence under two or more enactments, then the offender shall be liable to be punished under either or any, but shall not be punished twice for the same offence. When in the case of a criminal offence, especially like murder, if you are going to be any criminal offence, if you are punished two times, it is called double jeopardy. It's called double jeopardy. That is that a person cannot be punished twice for the same offence. It's called double jeopardy. Okay. More than once. Similarly, there's a constitutional provision also that it should not be punished for the same offense more than once. So Mr. Ram, an advocate, has fraudulently deceived his client, Mr. Shah, was taking expert advice on taxation matters. Now, Ram is liable to fine for acting fraudulently under the Advocates Act as well as the Income Tax Act. Can you do it under both? No. He can be punished either Advocate Act or Income Tax Act, not under both. So whenever a legislation says something should be served by post, then it should be deemed to be effected by properly addressing, prepaying, and posting by registered post. A letter containing the document to have been effected at the time at which the letter would be delivered in the ordinary course of. Okay. So I have covered these points selectively. I have not covered it in extensio, but in the long lecture, you will find it is there extensively. You can go through it. Now I'm going to move on to interpretation of statutes, which is similar to this. So if you want to go there, once again, I will share my screen. Okay. So this is a very interesting topic. Try to cover it. And then move on to, inshallah, we want to start FEMA today. Maybe I make a beginning with FEMA today, inshallah, because our next class will be on the 2nd of June, which will again, inshallah, be the last class when I would have completed your syllabus. Coming to the point, interpretation of statutes, right? Notes is not there. Sorry. This is complicated. See, law is made by human beings, not by God. God is infallible. God is perfect. Man is by definition imperfect. Therefore, words of a statute may have ambiguity. What is that? Not antiquity, ambiguity. Ambiguity means capable of two or more than one meaning. The same sentence you may understand in one way and I may understand in another way. It is quite possible that there is ambiguity. Okay. Ambi means both sides or both views. So it is possible to have different view, both two view. Ambi is basically two. Like you say ambidextrous, can use both the hands. Okay, amphibian can live in both water and land. So ambiguity, both, two meanings. Both are equally applicable. What to do? That is when interpretation of statutes has to be taken up, sir. So even before we start, I will tell you where the words of a statute are clear and unambiguous, there shall be no interpretation. We'll come to this rule of interpretation later, but now itself remember that. You can't use interpretation just like that, right? So the topic is like we have to talk about certain terms, okay? And then the need and importance of interpretation. Lightly, Board of Studies material is elaborate. It's beautifully prepared material. You will enjoy reading it. In fact, it extensively quotes Lord Denning, which I am going to quote here. Extensive quotation of Lord Denning, LJ is there, which is a fantastic decision on interpretation. I would love to read it out to you here and explain it. It's a beautiful, definition of what is interpretation. Why interpretation? And why the court should not avoid interpreting. Okay. Luckily for us, our Supreme Court and our High Courts have been totally capable of interpretation. They have applied their mind and they have said, even though the section reads like this, given the situation, given the fact that the words of the section are capable of more than one meaning, we feel that this is the intention of the enactment and therefore this is the interpretation that has to be given. So like that, they have given orders. And we are able to use it and take it forward. Right. So, rules of interpretation are there. There are about 7 primary rules and about 2 or 3 secondary rules. Then, see, when there is an enactment, I can use certain aids or I can use certain parts of the enactment to interpret which one I can use, which one I cannot use. So you got internal aids, which are parts of the law, part of the enactment. If it is not part of the enactment, then it is externally. Or we have to go elsewhere. Like I said now, dictionary. I said you can refer to a dictionary. When the section when the act doesn't define, when you are unable to find, then you can. So when the act itself is clearly defining the word, where is the question of relative is clearly defined in Companies Act. Then if he says, my father's second brother's son is my cousin, sir, he is my relative, sir. No, sir, it's not your relative, sir. How can you say that, sir? Because the definition of relative under the Companies Act is clearly given, sir. Okay. We're able to get this. So that is how it is. When the word is clearly defined in the law, you can't go around doing interpretation. But if the word is not defined, then you can go for external aids, such as dictionaries, normally understood meaning. You'll also see contemporaneous exposition. How was the word understood at that time? At the time when the law was enacted. You can go there. All that is possible, brother and sister, only if the words of the statute are not clear or they have ambiguity and there is no support within the enactment to help you, then and only then can you go out. So, common man, the term statute generally means the laws and regulations of every sort. Okay. So the written will of the legislature constituted the law of the state. Okay. It's very, very important, my dear friends. Thank God. Every day in the morning when you are thanking God for favors already received, thank Him for one more favor, which is that you are living in a democratic country where every person can have his say and nothing can be done to you unless it is clearly stated in an act of parliament. The executive cannot overnight decide all those whose name is Srikanth will be put in prison. No. It has to go through parliament, become a law, again go through all this process, and then that law should enable the executive, the police or the income tax commissioner to do what he wants to do. If such a provision, if such a democratic constitutional framework is not there, my dear friends, we'll be living in totalitarian government. We'll be living where from the night they will decide and they will say tomorrow, from tomorrow onwards, you all can't come out, go. We will say when to come out, then only you have to come out. Okay. Of course, within that constitutional framework, in an emergency, certain extra powers will be given. But that will happen only during the emergency. After that, you cannot. Okay. I mean, as a future chartered accountant, don't take these things lightly and say, is it connecting with income tax, sir? Is it connected with the Indian accounting standards, sir? India is, sir. No, sir. Then don't tell me, sir. Please don't waste my time, sir. Because I want to study only India's income tax, GST, complete. Please don't waste my time telling history of Indian constitution. Nonsense. Why should I know whether India is a democracy or not? How does it matter whether in 1974 there was an emergency in this country and that the emergency was unlawful and it was struck down by the High Court of Allahabad, Prayagraj as it is now called, okay, where they said no, emergency is unconstitutional. Okay, so it needs, I'm sorry, they didn't say that. They said the election of the Mrs. Indira Gandhi was invalid. A court decided that when the Prime Minister in power, against the Prime Minister in power. Okay. So courts have not shied to do this and they have been powerful, which is why a judicial framework, a fair judiciary is the greatest protection you have. Okay, and they are the people who can curb the, the excesses of the executive. Okay, if at all. And once the executive knows that the judiciary would swing into action whenever there is a misuse of power, then they will also be careful. And even when a law is passed in parliament, a citizen has every right to go to the court and get it questioned. You can ask, is this what is in tune with the principles of natural justice? So the law can be struck down by a court. Or rather, at least the court can say, this is not in accordance with the principles of natural justice. Okay? And so on and so forth. So, depends. Of course, it's a very complicated constitutional law. It can be done. Okay. So, this is called a democratic process for which we just like, we breathe air and we drink water. We don't thank for what we have. We don't thank for the democratic framework within which we live. Only if you don't live in a democracy, you will understand what it is. Maybe if you live in Afghanistan, during the Taliban, then you will know why living in India in a democratic setup is so great. Anyway, so statute signifies written law in contradiction to unwritten law. Yeah. Section 3 of the Indian Evidence Act 1872. Did you notice that? 1872, ring a bell, Indian Contract Act. Incidentally, same author, Lord Macaulay, Indian Evidence Act or Indian Contract Act or all Indian, it's Lord Macaulay. So, Though we hate him, we hate that bugger. He was the guy who destroyed our educational system, for which we have done no amendment. We have done nothing to change the Macaulay system in the last so many years. But still we blame Macaulay and we say Macaulay. But Macaulay only made us clerical. Correct. We have done nothing to change learning by rote and clerical exam, capable of becoming good clerks. People still produce. Okay. No. Right. So the Indian Evidence Act 1872 states that document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used, or which may be used for the purpose of recording that matter. It's a beautiful definition. Indian Evidence Act. Okay. Why I love this now? The word substance. See, the man is drafting this law in 1872 when they were writing on parchment paper with quill pens. Paper itself was not, as we know, was not in vogue. It was still parchment, and sometimes the thick rag paper was used only for legal documents. So today paper is ubiquitous. We just use paper without even understanding what it is. But in those days, paper was a precious thing. So writing. But he could have easily said upon paper. No, because he realized that he was writing on parchment, or maybe he was writing on basically vellum, which is basically dried leather, or he was writing on thick paper. Okay. Whatever it is, he knows that this substance will change, that people may write on other substances. Finally, he realized that they may not. See, today, most of what you read is not on paper, is on a screen in the computer. I am now reading something which is on a screen. So when I create a Word document, it is a document. When I convert it into a PDF and I send it to you, you don't print it. You read it on your mobile document. Any matter expressed or described upon any substance by means of letters, figures, or marks. I mean, this guy was prescient. He knew what he was talking about. And he ensured that his definition will live for 200 years, more than 1872. Now we are 2022. He would have completed 150 years of this definition. 150 years it will continue. You cannot touch Macaulay. I mean, you may not like him. I also don't like him, but you can't touch this definition. Okay. So compare it with the General Clauses Act definition. So the term document shall include any matter written, expressed, or described upon any substance. Again, substance by means of letters. I don't know if the General Clauses Act was, in my knowledge, the General Clauses Act was not drafted by Macaulay, but I'm sure the guy who did it obviously read Macaulay's Indian Evidence Act. Obviously was an expert in the Indian Evidence Act. The Indian Evidence Act is a beautiful enactment. I used to teach it for the company secretaries. In fact, my son, who is now an advocate, attended my Indian Evidence Act class. When he was preparing for law, he attended my Indian Evidence Act class. And so when I gave the explanation of the Indian Evidence Act for the company secretaries, though I'm not an advocate, okay, because I was taught by one of the greatest advocates. This particular topic was taught to me by one of the greatest advocates, Indian Evidence Act interpretation, by Professor K. S. Anantaraman, my guru. He taught me as if I'm an advocate. Which is one of the reasons why when I became a chartered accountant, I wanted my son to become an advocate and become the true successor of my guru. So the term document shall include any matter written, expressed, or described upon any substance by means of letters, figures, or marks, or by more than one of those means, which is intended to be used or may be used for the purpose of recording this matter. See the meticulous drafting. See, what I wanted to appreciate is the meticulous drafting which went into these laws. I only wish the lawmaker of today would apply this type of meticulousness in drafting the new laws. See, then these new laws cannot be touched. They will become so powerful, but weak language, ungrammatical, illogical, translating from vernacular into English, all sorts of things. Because, you are talking about legislature here. So the word instrument is also defined, which is instrument means a formal legal document which creates or confirms a right or records a fact. So it creates a fact, records a fact. Let's take, for example, lease agreement is an instrument. It creates or confirms a right of the tenant, or call him the lessor, the lessee, to use the property, okay, occupy the property. The lease agreement confers an inalienable right of possession during the pendency or during the subsistence of the lease agreement. It also records, right. Similarly, it confirms the right of the lessor to collect the rent. The lessee can possess. Lease communicates a limited interest in the immovable property known as possession. Very, very important. Okay, lease, you get possession. Friends, you let out your property, thereafter you cannot enter your own property. Because the man who's paying the rent has the right of possession. That's against the whole world. Of course, he has not got the ownership which you have, but he has the right of possession. But you have the right to receive the rent. So the instrument called the lease agreement, which is an instrument, confirms the right. Forget it. We talked about the affidavit. You remember in the General Process Act, where I only make a statement. So I say I am so and so, residing so and so. I confirm that blah, whatever, and then I say I swear or I solemnly promise and swear that what I have stated above is correct, is true to the best of my knowledge and belief, blah blah. So you can sign. It is only recording a fact. Still, it is an instrument. It's only recording a fact, but it is an instrument. Are you able to understand? That's why you take your partnership deed. Next time, the minute you go for articleship, you'll be coming across partnership deeds. Well, look, there will be a cost, there will be a name and all that. Then they'll say, now therefore, this instrument showeth as follows. Or now therefore, this instrument provides as follows. Okay. So it is a formal writing of any kind, such as an agreement, charter, or record drawn up and executed in technical form. It also means a formal legal document having legal effect. See, most of you are going to become chartered accountants without learning how to draft. But once you become practicing members, whether you like or not, your client will expect you to draft it. So even if the institute is not teaching you, you learn how to draft. Okay, somewhere you learn how to draft legal documents. Sometimes they might ask you to draft, especially partnership deeds. Section 2, subsection 14 of the Indian Stamp Act states that instrument includes every document by which any right, liabilities are proposed to be created, transferred, extended, extinguished, or recorded. Right? Now, what is the difference between an agreement or a deed? Okay. Both are instruments. Deed is also an instrument. Agreement is also an instrument. But deed goes one up because an instrument in writing or other legible exploitation on parchment or paper affects some legal disposition. Don't be frightened by this word disposition. It merely is a very, very fancy term for transfer. Simply stated, deeds are instruments, though all instruments may not be deeds. Which means agreements are also instruments, but they are not deeds. Affidavits are also instruments, but they are not deeds. But in India, we use these two words, instrument and deed, but agreement and deed never confuse. See, when a lease is for 11 months or less, it is an agreement. The minute it is 12 months and above, it is a deed. Because the minute your lease deed is, if your lease period is 12 months and above, it is registrable. It is a transfer of limited interest in immovable property, and as such, it is registrable. So if you're going to have a 3-year lease of your property, then it has to be registered. It is a lease deed. That's why most of us have 11 months. Why? Because we don't want to register it. So it's an agreement. Don't call it lease deed. The minute you say deed, then you're out. It is a legal disposition. It is a transfer of limited title in immovable property to the extent of possession, right? See, what I'm doing is consciously taking you through the legal terminology, helping you to appreciate the law. Okay, kindly get into this and try to understand these terms and use them. Because as a professional, you would be expected to use them. Okay, and be aware of the meaning of these terms. So tomorrow, if these terms are used, you cannot what kya like that you cannot say. You should be aware. If somebody uses the word deed, agreement, you should know what it is. And you see one more thing. You should be able to have a meaningful conversation with your fellow professionals, the company secretaries and advocates, who would be well versed in these topics. I don't know about the company secretaries, but definitely the advocates would be too well versed. Company secretaries also. If they are really, really intelligent, they will be well versed. I have met a lot of company secretaries who are extremely good at this, extremely good at it. So when you talk to them, you cannot appear to be in the same way that they learn accountancy and costing and all that income tax and all to be able to talk to you, but to an extent understand what you're telling. So when you say, the 222E will apply, Mr. Srikanth, don't you think so? Then this company secretary cannot keep staring at you. He should understand what is 222E, minimum. Named dividend model. Minimum. You should know. Okay. That much you should also know about law. Interpretation signifies expounding the meaning of obtruse or abstruse words. Confusing. So basically, interpretation is expounding the meaning of tough and confusing words, writings, etc., making out of their meaning, explaining, understanding them in a specified manner. A person is thereby aided in arguing, contesting, and interpreting the proper significance of a section, a proviso, explanation, or schedule. In relation to statute law, interpretation is of importance because of the inherent nature of legislation as a source of law. See, as I told you, law is made by men, drafting it in language in parliament. So it's not made by God. Unlike the Ten Commandments, directly given to Moses by God, okay, in the wilderness of Sinai. No, this was drafted by human beings. Okay, so interpretation serves as a bridge of understanding. See, we use the words interpretation and construction. These are, see, let's not break our head too much. If you want to use, you can use them. What shall I say? What do you call that? You can use them as similar. They are, what do you call them? They have the same meaning. No problem. You can use the same meaning, but synonym. They are synonymous. Okay, you can use them as synonymous, having the same meaning, but slight. If you want to have a slight shade of meaning difference, see, in interpretation there is an ambiguity in the statute. Please understand. In interpretation there is an ambiguity in the statute. So we are using the words. We are taking the words of the statute, trying to understand them, and giving meaning to that statute. That is called interpretation. Okay. Sometimes there is some confusion, but the words of the statute are clear, but there is a confusion between the words and the avowed intention of the legislation. How do I know the intention of the legislation? You will understand it better when you come to rule of reasonable construction. There you will understand. See, the words are grammatically correct, but if you give effect to it, you will see there is a purpose of the enactment that will not be served. It may even go against that. In which case, what to do? Okay, then that is when you have to construe. So the verb here is construction is the noun. The verb is to construe. Sorry, to construe. See, when you use the word construction, remember there are two ways: to construct a building, to construe and enact. both result in construction. Okay. To construe. So when you construe, what you do is you take this law and you say, hey, this is what it says. But if you give effect to it, it will have result in a manifest injustice to the citizen or the taxpayer because this is not in accordance with the avowed purpose of the legislature. How do I know the purpose of the legislature? There, I have to go outside. That is when construction may take you outside because you either that or inside, if you want to find out, go to preamble. The preamble for us, we'll come to that later as part of an internal aid. The preamble will clearly mention what are all the avowed goals. Try to say, hey, if you interpret this way, it goes against the avowed purpose as stated in the preamble. So, for this purpose, the preamble is a part of the act. Having said that, you might also want to go outside. Where can I go? The minister, while introducing the law in parliament, would have made all sorts of statements. Okay? At that time, the mood was like that. The then governmental policy was like that. Something they want, blah, blah, this is what we want to do. We want everybody to have 1 pound of gold. Whatever it is, whatever was stated there is definitely an intention. Therefore, you can go there. This is what was stated. If that is so, this goes exactly against what was stated at that time, right? We come to a very beautiful judgment of Lord Denning, wherein Lord Denning himself used the justification of this. This is there in the Board of Studies material. I am not giving it from anywhere else. It is there in extensio. I am actually further reducing it and taking only the essence of it and giving it here. The entire statement of Lord Denning is there in the Board of Studies material. If you have the pleasure, please go and read it. Otherwise, at least I thought I could share this beautiful passage with you. The English language is not an instrument of mathematical precision. See, mathematics, you can have exact equation a plus b equal to 2a minus 3b, whatever nonsense. But the English language is not an instrument of mathematical precision. See what Denning says. Our literature would be much the poorer if it were. See, much of Shakespeare is pun. Much of Shakespeare is double meaning. If you're going to be very precise, then Shakespeare could not have written what he wrote. This is where the draftsmen of Acts of Parliament have often been unfairly criticized. Okay. See, Lord Denning himself was a great lover of literature. In fact, if you read Denning's books, he has got one book of anthology of literature he loved. It's beautiful. So he was a great reader of literature. But he says, see, when you come to law, you have to be precise. But you have to use the English language. And he goes only for the English language. Do not think that any other language would be easier. Sometimes, it is argued. See, just like we have this argument of which language is good, bad in this country and all, the general argument given by the French is that French should be the language of Europe, entire Europe, including England. Including England. So English simply laughed and said, we have our own language. Bye. So though the French kept on insisting that ours is the precise language, ours should be the national language of Europe, like that. Yeah, it was adopted elsewhere, Switzerland, Austria, even parts of Germany, they adopted French. But English said, no, sorry, we got English. Even though English is not the language of mathematical precision. So in fact, if you go to France, you will generally find they would not speak in English. See, when you go to France, for you, any country outside of India should speak English. Sorry, no. The same mistake we do here with a language we do there with other language. You say, I know English, you speak English, but the Frenchman will not speak in English. They will speak only in French. That is their language. So when I had this peculiar, when I was touring with a group of people, one person was speaking and the lady spoke in French. The gentleman did not know French. He knew only English. He wanted bread. So he was asking, can I have bread? That lady, yeah. So she was asking, what? And then I interpreted because I know French. I said, so he wants to, So the point I'm trying to make is this: you have to speak in that language. What to do? So when I just laughed at him and said, sir, whenever it's convenient, you want to speak English, huh? So there, no, you have to speak their language only. No, Mr. Srikanth, they should all speak English. No, sir, in our own country, many of us speak English, but you prefer not to. But here you want to speak English. Wow, how nice of you, I say. Okay, but the French lady understood from my French and she said she helped him. So a judge willing himself to be fretted by the supposed rule that he must look to the language and nothing else, laments that the draftsmen have not provided for this or that, or has been guilty of some or other ambiguity. Sometimes when I used to comment about the section of the law and tell my guru, sir, this section is badly drafted, he will quote this. Do not blame the draftsman. You interpret it. Get down and interpret it. There was one nefarious section in the old 99 law with the old 2000 and the 1956 law, which my guru and I we almost came, there was mild disagreement when he said I interpret in one way. He said I do not agree. This is how it has been interpreted. Like that. It's so confusing. Luckily, the provision is not there in the new law. Okay. Of course, once there is an ambiguity, we have to. He kept on saying you cannot reduce it to a fidelity. You have to give life and soul to the enactment, which is what Denning says. It would certainly save the judges trouble if acts of parliament were drafted with divine prescience and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of parliament. And he must do this not only from the language of the statute, but also from consideration the social conditions which gave rise to it and of the mischief which it was passed to remedy. So mischief means here, what was the fault or the, shall we say, defect in the earlier law? That was to be remedied. No, why? What was it that was done? And then he must supplement the written word so as to give force and life to the intention of the legislature. Very famous quote of Lord Denning. See, company secretaries have a lot to thank Lord Denning because he brought them out from a purely ministerial person to a administrative and ministerial person to an officer of the company who has the right to bind the company. Whereas chartered accountants, he very clearly put us in our place and we said, earlier we were all hiding behind the classic judgment, where we said Kingston Garden Mills case, we said, an auditor is a watchdog, not a bloodhound. So we said, either way, I'm a dog. Auditor is a watchdog, not a bloodhound. Therefore, he is not expected to detect fraud. Okay, like that. So the Denning said, no, you may not. He elevated us from canine status, and he told very clearly, auditor is he is supposed to look into the books of account, and if his suspicions are aroused, he shall not fail to investigate. So our good old Kingston Garden Mills was put out. He said, when his suspicions are aroused, he shall not fail to investigate, which is what is now supported by the MCA in the new law, where they say, where you see there is a fraud, report it. Okay. So this was thanks to Lord Denning. Of course, at least Lord Denning raised us from the canine existence to human beings. So either way, you are a watchdog, not a bloodhound. Either way, you are a dog. So now he said, you are not a dog, you are a human being. When you are auditing a company, if you come across a fraud, please further investigate and report it. So there are, as I told you, about 1, 2, 3, 4, 5, 6, 7 primary rules and about 2 or 3 secondary rules. So the primary rules we will see quickly. The rule of literal construction. It is the cardinal or primary, important, all are one and the same. Rule of construction. With words, sentences, and phrases of a statute should be read in their ordinary, natural, and grammatical meaning. The words and phrases of technical nature are prima facie to be used in their technical meaning if they have any, or otherwise in the book, right? When the language of the statute is plain and unambiguous and admits of only one meaning, no question of construction or interpretation of a statute arises, for the act speaks for itself. This is further brought out in a Latin maxim. Absoluta sententia exposito non-indigent. Plain language does not need an interpretation. Absoluta sententia exposito non-indigent means clear proposition needs no expositor. When you have plain words, there is no need for explanation. Okay. Sometimes, I tell something to somebody, what do you say? What do you mean, Mr. Srikanth? I asked him, which part of the sentence did you not understand? Okay. Once one guy was shouting at me and he was coming and creating nuisance to me. I said, please get out. What are you saying? He said, 3 words, please get out. Which part of it you don't understand? I don't understand. I have been polite to you. I'm saying, please get out. Means go out. What more do you want? I mean, when the words are plain and unambiguous, there is no need for further explanation. Okay. something like that. Okay. In Tamil Nadu, we have a famous author called Kona, he has written notes for Tamil books, the Tamil exams. Those who write examination in Tamil from school, right from school, so some of it is tough Tamil, no? Ancient Tamil. So Kona has written this notes very beautifully, and it is very popular. And the Konar notes. Sometimes I used to tell people, I have spoken plainly. Why are you expecting Konar notes for that? What more do you want? See, in simple sentences are used where absolute maybe. See, the problem with most people is it is not that they don't understand. It is that they don't accept. That is not my. I have told you what I wanted, or what I told you what you have to do, or what you can do, what you cannot do. But if you don't like it, then what can I do? See, the facts are clear. The law is clear. The conclusion is clear. It has been put in words to you. So you are telling I have to pay tax? Yes, you have to pay tax. How can you say that? You just heard me say that. Okay. The reluctance of the average person to pay tax is sometimes comical. Okay. So generally the words or phrases of a statute are to be given their ordinary or literal meaning. But now we have rule of reasonable construction. You got it? To know literal. Everything is clear, absolute, sententia, expositor, non-indigent. But the minute you say there is a ambiguity, the law is capable of two meanings, or the grammatical or literal construction leads to a manifest absurdity. Manifest means clear. Manifest. Hidden, manifest. So that's why, sometimes when you make a list of items which are there in a cover or in a chest, it's called manifest, where what is in the box is made manifest, clear by the list. Manifest absurdity, then the courts shall interpret the statute so as to resolve the inconsistency and make the enactment a consistent whole. But see, this also there's a Latin maxim. Yeah, some of you may be irritated with all these Latin maxims. I totally appreciate your irritation, but the fact remains, why Latin? Because we adopted the law from British, who in turn adopted the law. The law for the British was made by the Romans. See, you and I were conquered by the British. Are you aware that the Britons themselves were under the rule of Rome for a long time? Julius Caesar in 50 BC conquered Britain. Thereafter, Claudius, Britain was very much under Roman rule. And thereafter, post-Claudius, Nero and all that, the control slowly weakened. And by the time, the later Roman emperors came, the decline and fall of the Roman Empire, Britain became separate. But the Roman law had been so deeply ingrained in the legal system that, for a long time, even though Britain became a separate country, the rulers of Britain were still paying, homage to the Pope, who sat in Vatican in Italy. Therefore, and Latin was the language of the church, the Roman Catholic Church. So language of, who were in initial stages, the interpreters of the law. The Catholic priests were the interpreters of the law also. Therefore, Latin, and then we adopted, they adopted it from Rome. And so on. So that the Roman law became the law for a long time. Latin became the law for information. Even when Mahatma Gandhi went to England to study law, he studied Latin. And in many cases, right up to easily Victorian times, arguments in court were made in Latin, fluent Latin. Right, but then of course they made it English. Now the point is, so still we use these Latin maxims or Latin terms. It would be nice if you know them. Not knowing them is not a crime, but knowing them is a great advantage. So, interpretatio fienda est ut res magis valeat quam periet. Sometimes this is simply called ut res magis valeat quam periet. The idea is, where there is a confusion, then use that interpretation which gives meaning rather than reduce it to futility. So this is called rule of reasonable construction, which is, my guru always goes by this. He says, Srikanth, don't reduce it to futility. Always give life and soul to the enactment. So while interpreting a law, two meanings are possible. One making the statute absolutely vague and meaningless, and the other leading to certainty. Then the latter interpretation should be followed. This has been sort of consistently followed, but some comical sections are there in the Companies Act which However much you try to apply rule of reasonable construction, you will go mad. If the court finds that giving a plain meaning to the words will not be fair or reasonable, it becomes the duty of the court to depart from the dictionary meaning and adopt the construction which will advance the remedy and suppress the mischief. Advance the remedy. Advance the remedy means give relief or and prevent the suffering or prevent the mistake. Okay. But you have to go by logic. See, opposite of conjecture and surmise is logic. You should have logic by your side. See, sometimes, you may not have total legal support, but there should be some logic. Logic. In fact, when I draft some appeal submissions, I don't use the word logic. I can't say what you're saying is illogical, but I will say you have to look at the probabilities of the case. So I will build a factual case, which I will show it and say, given this factual framework, the probability is that my assessee did this. This is the logical conclusion for what my assessee did. Now, unless you refute the facts, then you cannot simply presume that he's done this. Where there are in an enactment two or more provisions which cannot be reconciled with each other, there should be. This is called harmonious construction. Sometimes what will happen, in the same enactment, one section will provide in one way, another section will provide in another way. And there's such a conflict. It's called conflict. So the opposite of conflict is harmony. So when there is a conflict, it is the duty of the court to bring harmony. Sometimes, there can be harmony within the law itself. For example, whenever a law uses the word notwithstanding, automatically the legal intention is known. Notwithstanding anything provided in any other law for the time being in force. That means what? Whatever other sections may say, ignore it. This section is standing alone and it will be this, whatever is saying is correct. So that notwithstanding is a great support. The minute section begins with or provision begins with the words notwithstanding anything contained in this act, or notwithstanding anything contained in this section, or in any other section, or in this act, or in any other act for the time being in force. 4 levels of notwithstanding. Whichever level so that extent this section will be superior. So the superiority of a section that is not there, then provisions of the law providing for the same matter, I should ask, which is the general provision and which is the specific provision? The specific provision will override the general provision. So this is called generalia specialibus non derogant. The general cannot take away from the specific. That means the specific will override the general. Right? So that is why sometimes we say without prejudice to the generality of the following. There what we mean is, what I'm now going to say is an exception. Whatever was said earlier is the general. Without prejudice to the generality, it's almost like a provision. When we say provided that, we mean whatever we have stated on top will apply in general, but specifically this will apply. In this circumstance, this will apply. So the provision itself can create a specific provision, specific exception. That is, of course, when there is a provision, I have no problem. But there are two sections, one providing in one way, another way. I have to see which is general and which is special and conclude that it's a special provision there. Even though the general says like that, still the special can be taken. Generalia specialibus non derogant. The rule of harmonious construction is applicable only when there is a real and not merely apparent conflict. As I told you, apparent conflict will happen where you can clearly say, hey, this is applicable only in this situation. Otherwise, that will only happen like that. Okay. When after having construed their context, the words are capable of only a single meaning, then you cannot use harmonious construction. Beneficial construction is used, say, first of all, Beneficial construction is a different concept. It is used for economic legislation, which are social legislations. And as far as the Board of Studies material is concerned, the rule of beneficial construction or the Hayden's rule is here. The beneficial construction rule is also there, but as far as the institute is concerned, beneficial construction and Hayden's rule, one and the same. Of course, when you apply Hayden's rule, in a way you are using beneficial construction. But beneficial construction is a totally different thing. Where there is an ambiguity in a law, you can give the benefit to the citizen, especially where the law wants to give a benefit to the citizen, where it's meant to bring about social equality or justice. And there is an ambiguity in that law. The benefit can be given to the citizen. The law need not be restrictively interpreted. Can be loosely interpreted, beneficially interpreted. That is the beneficial construction. But normally, when they say beneficial construction, you write Hayden's rule. Okay, Hayden's rule was decided in a famous case, Hayden's case, by the barons of the realm, who decided where the language used in a statute is capable of more than one interpretation. The most firmly established rule for construction is Hayden's. This rule is also known as purposive construction or mischief rule. So, तीन नाम है ना, beneficial construction, Hayden's rule, mischief. Three names are there. That's true. So, whenever there is an ambiguity, go to the old law. This is what the barons of the realm, while deciding the Hayden's case, they said, what was the law before the making of the act? What was the mischief or defect? What is the remedy that the act has provided? What is the reason for the remedy? How to give that remedy? So, see, this is the beauty of it. There was a problem. You passed a law to solve the problem. You created more problem. Now, how to give the solution to the original problem? Give that. That is called rule of beneficial construction. Interpret the law in such a way that the original purpose is served, for which you have to make an inquiry into the intention. You have to go to the previous law. This will take you outside of this enactment. It's okay. But you can do that only if the words used in a statute are capable of more than one interpretation. Right? So this is also very interesting. Then there is a rule of exceptional construction, which is used for the elimination of in the statute of words which defeat the real objective, similar to beneficial. Okay. For example, where they use the word or and, I already explained it to you. Or is disjunctive and is conjunctive. So when they use and, both have to be satisfied. When they use or, it is enough if one is satisfied. However, sometimes if it is repugnant, then they may use or and. Okay. In rare cases, sometimes if or is not there, if you cannot substitute and, where you have to use only or. Where the act is silent, you cannot substitute and, you can only substitute or. Because and has to be specifically mentioned. If nothing is mentioned, it is only or. There is a list of conditions without any disjunction or conjunction. Only the disjunction can be used. You cannot use the conjunction. Ideally, when you are drafting, when you are the drafts person, remember to include the or and all correctly. Please. May, must, and shall. Simple ma. May is an option. It is a power. When the law says may, then may includes may not. When the door, you say the door is half open, it isn't half shut. So when I say you may do, it includes you may not do. There's an option. The minute I give you an option to do, it carries with it an option not to do. But shall indicates no option. You shall do it. Okay. Sometimes what happens, you make a mandatory provision and then you make it, for example, the company shall change its name by passing an ordinary resolution. It's a classic example where, though the word shall is used, it will become may only. That is why they have changed. They said, in case the members do not pass, then the central government itself can change the name. The earlier law was, I used to point out, and again, my guru used to shout at me, don't. I didn't say what to do. See, these guys are saying you shall change the name, but they are saying by passing an ordinary resolution. See, I am saying simple. I want to do it. I am the board of directors of the company, sir. I'm calling a meeting. All the members are coming. I cannot take a cane and beat them and say, pass the resolution, pass. If they don't pass it, what do I do? Then you are saying shall. I called the meeting, they came, read out and said, our name is called, our company's name is called Debagur Limited, but central government says it should be changed. Please pass the resolution. They say, no, we want only Debagur. Because you can't do that. Central government says, I don't care, central government. They don't pass the resolution. They don't vote in favor. Yeah, what can I do? M is a company secretary, he is a director. How are we to be blamed? We're able to understand. You may make a provision mandatory, but if you build a option into it, automatically it becomes optional. That is my complaint. In fact, first time when I presented a paper on company law, that was in 1990, 1989. 1989. First time I presented a paper on company law. I said certain thoughts on company law. I took about 5 or 6 sections and I said, this is what. Supreme Court advocate Mr. Arvind Datta was there. He said, hey, Srikanth, how you are telling? So what to do, says my, no, what Srikanth says looks serious. Let's look into it. Because he was at the time writing a treatise along with Justice Chandrachud. He was revising Ramaya. Mr. Datta was revising Ramaya. Maybe see, somewhere all this must have reached somebody or the other, and they said, no, some idiot chartered accountant in Chennai is talking nonsense like this. Let's not do that. This time, even though they could have easily taken it up and said, look here, he has got a name which too nearly resembles the name of an existing company. Why ask him to change? You change it, man. Okay. But that is why the boss is there. They have the power now to change. In case you don't. So it's like now they are giving you an option. Change, please change, my dear child. No, then take the cane and hit him and change it. Okay. So this is the basic concept of may and shall. Must and shall have the same meaning. Do you remember Registrem Generis, where specific words are there, followed by general word? Then the general word shall be read as if belonging to the same class or category or genus as the specific words. So, for example, it so happens that recently I went for a tour where I went to. I recently did go for a tour where I went to Ayodhya, Varanasi, and Prayagraj, and other places. I went to Ayodhya, Varanasi, and Prayagraj, and other places. Now, this other places is a wider term. So, what places can I include? Now, first of all, is there an enumeration of specific words? Yes. Ayodhya, Prayagraj, Varanasi, 3 places, right? Do they form a class or category? Broadly, they form a class of category called pilgrimage centers. So now, is that class or category exhausted? No. You have Naimisharanyam, you have Dwarka, you have Mathura, you have other places also. You have, Gaya, you have so many places. It's not exhausted. So other places, in which case, other places can include Gaya, Dwarka, but can it include Shimla or Corbett? No, because those are places of leisure and pleasure, not pilgrimage center. I'm giving an example. Another example, lion, tiger, leopard, and other animals. Can I include Kaziranga, rhinoceros? Again, examine. Are there specific words? Yes. Lion, tiger, leopard. Do they constitute a class or category? Yes. They constitute the class known as Felix, which is the cat family. Wild cats. Now, rhinoceros is not a wild cat. Therefore, I can include cheetah. I can include jaguar, puma, but I cannot include rhinoceros. Okay. So, this is the rule of Aegistem Generis. There should be no indication of a different legislative intent. Remember, if you remember what I did in auditing, I said business transaction. I said, services like they said airline, telecommunication, like that, or hotel and all. Do they form a class or category? Services. But I think even then they are not broadly indicative of all services. Okay. So I will say that they are not forming a class or category. Therefore, and similar services or similar will not goods or services I can use it widely. Okay. So please remember, Aegistem Generis is not a binding rule. It is a rule of interpretation. Okay. So you have to use it with discretion. But remember this rule. Whenever you see a list of specific items followed by a general, immediately ask yourself, does it follow? Usage or practice developed under the statute is indicative of the meaning. So sometimes usage itself defines the meaning, etc. So contemporaneous usage. How was the word understood at that time? Also needs to be taken. And quickly going through the internal aids. See, in the law, within the enactment, you have functions, the scope, object of the enactment, heading and title of a chapter. Be careful. Sometimes chapter headings were not there when the act was passed in Parliament. The next time when the budget is announced in Paris, the next June, some finance minister is going to read the budget. When the budget comes out now, read the printout of the budget as presented in Parliament. You will not find any headings, titles, and all that. Later on, when it is enacted in Parliament and the Finance Act is printed, some bureaucrat will add titles, headings, and all. So there is a view that headings and titles cannot be used. So there is also a view that a heading or title can be used in the same way that the preamble is used for the entire act. That is also there. Definitely, marginal notes cannot be used. Why? Because marginal notes were written by a bureaucrat after the law was passed. Luckily for us, the new laws, almost post 1990, you will not find a marginal note. Nobody is having the time or knowledge or energy to write a marginal note. So definitional sections, we already saw them, interpretation clauses, etc. Okay, restrictive and extensive definitions. Relative is a restrictive definition, exhaustive definition. Whereas there are inclusive definitions where they say books and paper include, like that. So includes means you can include. Whereas means no inclusion, only that. Means and includes means includes only. It is not exhaustive. Okay. Ambiguous definitions are possible, in which case you have to interpret. Okay. Go for the dictionary meaning, whatever. Okay. Like, illustrations are used. Today, in the new laws, you will not find any illustrations. But in the old laws, like negotiable instruments, luckily it's not in your syllabus, Contract Act, Sale of Goods Act, you'll find all the illustrations are there. Okay? So those illustrations cannot be used for interpretation, except because they are only meant to explain or to give a practical the section can be very abstract. So once I give an illustration, I'm taking that abstract and making it specific. But you cannot use the illustration and say, sorry, it's like this in the illustration, therefore that is what will apply there. The words of the statute will be superior to the interpretation. Okay. Even if it is ambiguous, you can't use an illustration. Proviso, as I said, now will create an exception, carve out an exception. For a specific situation, they will say this won't apply. And exceptions are there where in many sections, now you'll find there will be one subsection which says the above section will not apply to blah, blah, blah. There is an exception. Proviso is where in that subsection itself, after providing this, they will say provided that. The following. Saving clause. In case there are certain rights and remedies which are already available, the section may be removed, but still they will say this subsection alone will continue to be applicable. Explanations are used to give further meaning to the words. So they would act the same way as the definition can be used. Schedules, okay, can be used for construction. The Companies Act of 17, all the schedules can be used. Okay, and we also have external aids of interpretation, like historical setting. See, you can go to the external aid only if the internal aid fails. If the internal aids are clear and available, you have to use only internal aid. If internal aid is not available or not clear, then and only then are you allowed to go out, like historical setting, the consolidating statutes and previous law, usage. How is it that normally done in this? Earlier and later acts and analogous acts. Analogous act, I told you, Specific Contract, Securities Contract Regulation Act, SEBI, and Companies Act are analogous acts. Dictionary definitions allowed. provided you exhaust all this, the definitional section, explanation in the section, if any, general classes act, nothing. Then you go to ordinary dictionary meaning. Use of foreign decisions. See, foreign decisions are not binding on Indian courts, but they have persuasive power. They have persuasive power. If you have a foreign decision which supports your view, you can quote it and you can say, sir, this is what the European Union Court has told. Okay, we will consider, because the Supreme Court of India is the supreme judicial in this country. So if that Supreme Court decision is there, that will be more superior to your European Union also, or even the Supreme Court of America. Okay. Incidentally, there is no one single Supreme Court. Each state has its own Supreme Court. It's a federal. Only in India we have a one single. So the point we are taking is foreign decisions can be persuasive. In fact, many appellate commissioners, even Indian decisions, are only persuasive. When I go to them and say, sir, Madras High Court decision is Hena. Sir, Madras High Court, no, they can also be wrong like that one. Say it is, sir, if you think Madras High Court is wrong, because who can say Madras High Court is wrong, Not even a peer can say that. Means the order of a single bench, only the division bench can say it is wrong. Order of a division bench means 2 judges. Order of a division bench, only full bench can say it is wrong. Means 3 or more judges, only they can say this statement is wrong. No, it is telling it is wrong. I said, sir, if you think you are great like that, please write in the order. Madras High Court decision is wrong. They will be more than happy to go on appeal. And therein they will also see that here the person who has said Gujarat High Court decision is wrong. You write. Forget the contempt of court. You write it first. Then we will see what happens. Okay. So after that, that order was never passed. I told him openly, I said, sir, I have quoted Gujarat High Court decision. You are saying Gujarat High Court is wrong. I love you. Please write it and give. Don't tell. You wait to jail. Come on. Put it in writing, sign and then give it to me, so that I can go on appeal against it and try to test it in the tribunal. See, this language is what you have to pick up, because you will be appearing before authorities where you have to talk with confidence about law and the facts of the case, the applicability of the law, which is what the institute is also expecting from you. When you write an answer for law, an answer should be an argument supporting your view, the facts and the law, applying the law to the fact, giving the conclusion. So that, you should learn this writing technique when you're studying law. That is the purpose of this subject itself, to give you that type of training to write legal language, to write logically, to reach conclusions based on facts and law, right? So this is the topic coverage today. Yes, I still have 2 more laws, FEMA and LLP. Inshallah, we'll do it on 2nd of June. If necessary, we'll take another half an hour more and we'll finish it. So in the meantime, as usual, the Betal is asking Vikram, do you have any more questions? Do you want to ask questions? Every time this Betal is asking Vikram, do you have any questions? Vikram is not asking any questions. Please ask. If you have any doubts, you are welcome to ask me now, or you can even send a query to the Board of Studies, the faculty there who are extremely think and think. Pratima ji says all clear. Thank you. And whatever it is, hope you will. I'll just wait for another 3 minutes for you to ask. So, suggestion, read the Board of Studies material, listen to the lecture, and maybe if the notes are there, download them, first revision. Then again go through the Board of Studies and the notes that we have given you as part of your thing. Second revision. Nearing the exam, important questions, brush up. You are ready for law. 3 revisions, you are ready for law. Minimum 60%. Okay. Wishing all of you all the very best. Looking forward to meeting you on the 2nd of June. Bye. Sir, shall we close the class?
Thank you, sir.
Thank you. Thank you. Thank you.